Well, folks, we're here with Todd Blanche, who leads every criminal case in defense of President Trump other than Georgia. How are you, sir? We've never spoken, have we?
We haven't. It's great to talk to you, although I feel like I know you. The president reads everything you write and watches everything you say, so I feel like we're old friends.
You know what? I watch everything you do, and you're damn good. And I'll tell you what.
Absolutely.
you have to be damn good. You're in all these different courtrooms. You're fighting on different levels, you know. Manhattan is nothing like Florida. Florida is nothing like, you know, the January 6th, and yet you keep pounding away. So let's look at this right now. So where does Manhattan stand? You guys filed a fantastic appellate brief, a fantastic brief. So what do you do now? You're waiting for a hearing, what, in September sometime?
Yes. So the government puts in their opposition this week on Wednesday. We asked the judge for an opportunity to reply. He normally doesn't give replies to either party. I hope he'll give it to us. We'll put on a reply brief. But look, I think it's not open and shut in the sense that the judge still has to do some work and make a decision. But there's no dispute that a ton of evidence came in that trial that the Supreme Court has said absolutely, positively not allowed in. And so we're optimistic that the judge is going to do the right thing and throw that case out. But we're waiting till September. He's going to rule early September.
And you're sitting there. I'm sure you put yourself in the judge's position. How the hell do you separate it all out and pretend that the jury wasn't tainted? It's an impossibility, isn't it?
Impossibility. Listen, Hope Hicks testified about a conversation she had with President Trump in the White House, in the Oval Office, a key conversation responding to Michael Cohen when it was first released that he had made the payment to Stormy Daniels. In the summation, the government said that conversation was devastating to President Trump. The Supreme Court has said those types of conversations that a president is having with his key advisors are absolutely inadmissible at a trial. So that's, in some ways, should end the discussion in our mind right there. And, by the way, we begged the judge, literally begged to the extent that litigants can do that, to adjourn the trial till after the Supreme Court ruled. We put motions in. We argued orally. We said, Judge, this is going to be in April. That's soon. Let's put this trial off until the Supreme Court rules. He denied that, and he didn't let us do that. He let in, there's not a single piece of evidence he excluded because of anything to do with immunity, and now here we are. So we'll see.
And the fact is, the judge doesn't even have to hold a hearing, does he? He lets them reply, he looks at the papers, he rules on the papers, and that's the end of it, correct?
That's what he does. He doesn't have oral argument. He's never allowed us to have oral argument. He just rules on the paper. So we're stuck with that. A lot of judges do that in New York State. And that's right, though. That's right. We'll sit back and wait. In early September, he issues his decision.
Now, let's say he's trying to, put this puzzle piece together and so forth and so on. And then he either does something that day or in a future day, we're going to deal with sentencing. What do you do then?
Listen, we're looking at everything. I mean, and I mean that literally. I think depending on how he rules, if he rules against us, we'll look at the decision. If it's inconsistent with the Supreme Court, we have a lot of options. We can do everything from ask him to reconsider, which I doubt we'll do that, but we can do that, to go to the Supreme Court. And we're looking at every single option, whether it's appealing it directly to the First Department, which is the appellate court in New York, whether it's going across the street to the federal court in New York, the Southern District of New York, or going to the Supreme Court. Listen, if it happens, in our view, that is a crisis in America, and I mean that, and I don't say that lightly, because it's early September. He's then going to sentence President Trump September 18th if he rules against us. The election is November 5th, and it's crystal clear that this trial not only should have never been brought, but that the evidence that was used to convict President Trump, the Supreme Court has said it is not allowed. You say that to somebody, someone who's in high school or a civics, someone's taking civics, it writes itself. It's not complicated, that's it. So everything's on the table if that happens, and we'll see it depends on what the decision says, but everything's on the table.
My only concern is you get stuck in that laborious New York appellate process. You won't get it resolved for a while, but you're the lawyers, you're on the ground, you know what you're doing.
No, man. I agree with you. My partner and I were going to the First Department appeals so much that I felt like they were just going to give us a pass to get in, and every single time we lost. And so I couldn't agree with you more. But that's why we're going to be ready for everything. If we run into a brick wall with them when it comes to what's going to happen in September, we have options. We can go to federal court across the street. We have the thing that you report on, but a lot of people don't appreciate is President Trump has a great team around him, and I'm not talking about myself. I'm talking about John Sauer and Will Sharp, like guys that are really smart appellate lawyers, and Emil, my partner. And there's just a lot of folks, and we're going to reach the right decision. And when someone says to me, "Are you thinking about doing X, Y, or Z?" the answer that I always give them is yes. We're thinking about doing X, Y, and Z. Absolutely. So we'll see.
You guys have done a hell of a job. I don't see why anybody would be criticizing it. Let me ask you this. Let's move on to the next one. We have this January 6th case. I won't give you my opinion of the judge. I've given it to the American people already. I don't want to get you stuck in the mud here. But that said, they got a lot of problems. You've got the obstruction decision, and that obstruction charge was bogus to begin with. You've got a prosecutor who takes these statutes, this is his habit, and rewrites them and tries to fit so-called facts into the statute. You've got the immunity issue in front of that court, too. Has she set any time to deal with anything?
No, she doesn't have the mandate back. So technically, she doesn't have the case back, so she's not allowed to. What she's indicated to us through her chambers is that she's going to have a conference in late August. But before that, I expect she'll issue some orders. But you're right. This case is a mess. It is a mess. The obstruction charges should be gone completely. And the immunity decision, which was right, by the way. You read what Justice Roberts wrote, and you read the concurring opinions. Excellent. We need a presidency. We need a presidency where a president can do his job, do her job, without being worried about a Joe Biden of the world coming along and indicting him a year after he leaves office. So that's a good decision. But listen, there's no scenario under which this indictment looks the same. If anything, it's down to, a few pages. And I was a prosecutor for a long time. And what we're supposed to do as a prosecutor in charge with enforcing the criminal laws of this country, putting people in jail potentially, is do the right thing. Full stop, period. And so what is the right thing to do right now? In our mind, it's just dismiss the case. And, President Trump says that on Truth, and he says that when he's when he's talking to the American people, and he's not a lawyer, and he says it, I think, as better than I do, but I agree with him. They don't have to continue. They can say, okay, we indicted this case, and the Supreme Court has just told us that what we did was wrong. And the Supreme Court is the law of the land. We're prosecutors. We're going to shut it down. Now, do you think for a second that's going to happen? I certainly don't. No. And so we're going to be stuck fighting it with Judge Chutkan, and we will fight it. Listen, and on that case, we have John Lauro and his partner, and again, we have a rock star bunch of lawyers that are helping the president here, and we're going to be, the second that she gets a mandate back, you're going to see a lot of the president's lawyers just jamming to get that case completely dismissed.
Well, they have a third problem, don't they? That is, Judge Cannon ruled that the special counsel is unconstitutional. Now, she can rule that she's going to ignore it, but she really can't just ignore that, can she?
No, and look, the D.C. Circuit has previously ruled the other way, but if you read Judge Cannon's decision combined with Justice Thomas's concurrence, it's her opinion, and for those of us geeks like certainly you and I guess me that are lawyers and have time to read a 93-page judicial opinion, she went so deep in the weeds on that case. She went and got documents from the Nixon case in the 70s.
The law review article.
Neither party gave her those. She did that on her own because she wanted to get it right. And so it's a beautifully written opinion.
Todd Blanche leads every criminal case in defense of President Trump except in Georgia. Todd Blanche, I'm thinking about this January 6th case. It's not even a January 6th case. I don't know what the hell this case is. But that said, you've got the obstruction issue the judge has to deal with, and she has to get it right. The immunity issue she has to deal with, which is very, very complicated for them, too. And then, of course, you do have this issue overhanging this whether the prosecutor is constitutional, whatever that judicial jurisdiction is decided. It's something that at some point has to be resolved by the Supreme Court. You're going to have the ability to really slow this down to a glacier's pace, aren't you?
Right. And by the way, slow it down has been criticized by folks on the other side of the aisle as if it's a bad thing.
Yeah, exactly.
And the Supreme Court said, Justice Roberts said very clearly that the urgency and the expediency that everybody was going through this process was a mistake. And so we should go slowly. We're talking about issues that will affect America for generations to come. But you're absolutely right. Every one of these issues, especially the immunity issue, is going to go back to the Supreme Court. They almost invited it. They sent it back to Judge Chutkan with instructions for her to figure out what evidence was actually allowed in. But it indicated they wanted as full a record as possible before a trial, which is forecasting that they want to look at it again. And so this isn't going to be resolved before the election. The only question is whether Jack Smith and his team are going to try to do as much as they can before the election, in my view, just to embarrass President Trump and to make it impossible for him to be on the campaign trail because he's stuck in a courtroom in Washington, D.C. Look, think about New York. And I was with him for 6 weeks straight. He was in courtroom from the beginning of the day to the end of the day, 4 days a week, most weeks. And so you get one day off, a Wednesday. It's still very challenging to run a campaign when you're focused on your trial, when you're focused on all these criminal cases. So you would think that they won, right? Because they indicted him 4 times. They stuck him in a courtroom for most of April, all of May, and a little bit of June. And they think they have D.C. But the power of the American people is so amazing. And I've watched President Trump observe it firsthand because they didn't win. And he would leave that courtroom energized. We're all, you know what it's like, in a courtroom all day, Mark. You're exhausted. And he walks out fired up. It was, listen, he's an amazing man. That's for sure.
Remarkable. Now, here's the thing. So Kamala Harris, they've already leaked it to CNN. They're going to run on, she's a tough prosecutor and he's a convicted felon. Isn't that also another reason when you go into that court in September to say, look, we got to resolve this?
Yes.
You have handed another party a political issue. We're going to appeal this unless you resolve it right here. We need to get this resolved immediately because what's taking place here is absolutely interfering with the election process. So every time she opens her mouth about this, isn't that more and more evidence of what they're doing?
Oh, absolutely. Not only, yes. I mean, the short answer is you're totally right. But also the label of a convicted felon is so deceiving and so inappropriate and so wrong given the New York case. To those that sat through it and to those that know the case, we say this is a case that should have never been brought. Maybe we overplay that phrase. But when it comes to that case, I quit my law firm. I walked away from a partnership to represent President Trump because of that case, because I was so offended that an elected Democrat prosecutor would look at those facts and choose to indict a former president of the United States who was running for president again. Even if you accept every word that the prosecution put into evidence, which you shouldn't, by the way, but even if you did, it's not even a crime. It's not a crime. And so to now be able to label him a convicted felon and Kamala announced that she's a prosecutor because she was a prosecutor a long, long time ago in San Francisco is, you're right. It's the definition of election interference. It is. It's really unfortunate that we're here, but here we are.
Yeah, and as vice president, this prosecutor has allowed more illegal aliens, criminals, drug pushers, sex slavery, child pornography, gang members into this country, and I don't remember her arguing that these people should be prosecuted either. Let's move on to another issue very, very quickly, which is this. In that courtroom in Florida, the issue of the appointments clause. I'm chairman of Landmark Legal Foundation. We had some very smart lawyers there arguing with us.
Yes.
I watched and listened, my guys tell me that the two former attorneys general, they had great lawyers too, but they also said your guy was really, really sharp. You want to tell us a little bit about that?
Oh man, yeah. So we had a lot of help from those guys. The amicus briefs, Attorney General Mukasey showed up in that courtroom and sat next to us all day Friday, which is when you see a former, he was a former chief judge in Manhattan, a federal court, and then he was the Attorney General, and so that was powerful. But Emil Bovee, my partner, former prosecutor from Manhattan, chief of terrorism, and just he clerked for two great judges. He's an amazing legal mind, and he put together an argument that really makes logical sense. The folks on the left make fun of this decision, but it's a very basic concept in our judicial structure, which is that you're empowering somebody with the power to indict another individual, to send another individual to prison, to authorize search warrants. And what Congress has said and what the laws have said and what Article 2 of the Constitution says is that person that can be authorized to do those things, to such significant things to an American citizen, has to be nominated by the president and confirmed by the Senate. And there's certain exceptions, but I'll tell you, an exception is not that the Attorney General of the United States can just go find some private citizen and say, hey, why don't you come and prosecute and investigate and prosecute President Trump? No nomination from the presidency, no confirmation by the Senate. And so if you think about it again, as a high school civics student, that is completely logical and right. And so it took 93 pages to get there because it's a complicated issue, because there are exceptions and there's a lot of statutory construction and case law. But look, Emil Bovee, my partner, is the smartest lawyer I know, and again, assisted in a lot of ways with the amicus briefs and with the folks that we had helping us with our team. And Judge Cannon, it's easy to make fun of the decision because the D.C. Circuit came out a different way. Read that brief. Read the opinion. Everybody that calls me about it and asks me what I think, I send it to them. I said, read it and let me know what you think. So we'll see. But nothing made me happier, and hopefully the American people that maybe don't know the details, but to wake up Monday morning, the week of the Republican convention, and right after really one of the darkest days that we've had in a long time, on Saturday with President Trump almost being assassinated, and to have Judge Cannon just put her foot down and say, I'm not going to let this happen, this case is dismissed, it started to restore my faith in the justice system. I hope it did you too, but it was a good day.
And the efforts to intimidate her on cable TV and these clownish law professors and these clownish former prosecutors making these preposterous statements, you know what? It would have been very, very hard for me to come up with a strong argument against the position that this guy was appointed in violation of the Appointments Clause. And, at the Constitutional Convention, they spent a lot of time on this.
Right.
It wasn't a quick decision. They spent a lot of time on this. Hold on. And then the D.C. Circuit Court spent almost no time on it. Go ahead.
Right. That's right. By the way, this same liberal left media, former DOJ guys that are on all these stations mocking Judge Cannon, she is a Colombian-born, brilliant lawyer who was a federal prosecutor in the appeals unit, clerked for the circuit court. It's easy when a judge doesn't rule your way to mock and make fun, which is what they've done. But every time anybody does that, I just say, go read her opinions. Go read them. Tell us where she erred. Tell us where she did something that was a contrary to law, or even not didn't make sense logically. She was great. I mean, and I don't say that because we won. I say that because she took every single issue we raised with her, whether it was a very small issue or significant issue, and dealt with it like she was dealing with the biggest case in the country in a very thoughtful and I think appropriate way. So it really broke my heart to see. I was a DOJ guy for a long time. To see DOJ alumni just mocking her and criticizing her, it's a sad state. But guess what? We can fix it, and we're going to fix it, and that's why. I thought the convention last week was amazing. We're on our way to November, so let's go.
Todd Blanche, there's only one guy on cable TV that said that case is not a slam dunk, and that was me. And I'll tell you why, even if they got to the substance. But I think it's amazing. A lot of these litigators, don't they know about the motion practices and all? It's like,
Right.
what are you, crazy?
Right.
You're not going to get right to a trial here. People have motions to file.
Listen, I'm on all three cases, like 3 of the 4 cases. The Florida case, in my mind, had the biggest evidentiary issues of any of those cases. And yes, everybody's instinct was like, this is the quickest path to a conviction. No freaking way. Like that, I'm glad we won, but we had a lot going for us in that case. But by the way, I don't want to, that's not really the point of this conversation, I don't think. I mean, look, they shouldn't have been brought, right? It's why you shouldn't engage in lawfare. And I hope that we don't. I hope that when we take office, when President Trump is reelected, and he won't, by the way, he won't. If you look at how he acted when he was president, he won't do that because it's the wrong thing to do. And I respect him. I've respected him for a long time, but now I more than respect him. I think he's a real rock star for what he's going through and what he's doing. And I listen, I got nothing bad to say about that guy.
Todd Blanche, pleasure to talk to you. Pleasure to get to know you a little bit, and I'm sure the millions of listeners agree with me. Keep it up, baby.
Thank you. Anytime that you want to speak with me, you just let me know. I love talking to you. And like I said, and to all your listeners, one of your listeners is President Donald J. Trump. He listens to everything you say, and you were almost always exactly in line with what I was thinking, which made my job easier. So thank you.
Well, you're really kind. Keep it up. We really appreciate you. Take care, my friend.
All right. Thanks, Mark. All right, bye.
God bless.